দেশের প্রধান বিচারপতি তিনি বক্তব্য রাখছেন, সরাসরি নজর রাখবো সেদিকেই।
Speaks of contemporary judicial developments and strengthening justice through law and technology. The word contemporary is very important because it does not speak about the work which we do in the abstract, but in the context of contemporary societal challenges which we as judges face in the work which we do. We therefore look at law and its intersection of technology from the perspective of the societal conditions in which those whom we serve exist in our societies. Because the true merit of our work lies in addressing the challenges faced by those at whose feet we are intended to serve, namely the common citizens of India. The first important theme that we are going to discuss is the principle of constitutional morality. Now, if you look at the Constitution, the text of our Constitution does not use the expression constitutional morality. This phrase, into inverted commas, constitutional morality, is not found anywhere in the Constitution. The Constitution uses the expression morality, but it does not use the expression constitutional morality. Now, all of you may be asking a basic question, which is, why are we discussing a phrase which is not used in the Constitution at all? What is the relevance to district judges, high court judges, to the officers of the state, to civil society, of a phrase which is not used in the Constitution? The Constitution uses the expression morality, but morality in the Constitution is used as a restraint on fundamental rights. The Constitution allows for restrictions to be imposed by law on the right to freedom of speech and expression under Article 19(1)(a) by Article 19(2) on various grounds, including morality. Likewise, the Constitution contemplates that restrictions can be imposed on the right to freedom of association, inter alia, on grounds of morality. So morality in Article 19(2) and Article 19(4) is a restraint on the rights of the citizens. Is that the morality that we speak of when we talk about constitutional morality? Now, that's one of the basic questions which we have to address. If constitutional morality has not been addressed in the Constitution as a textual expression, what is the value addition to the constitutional discourse that we in a regional conference, a high-powered conference of senior judges from across the region, are discussing this concept? That's the first question which I must very briefly try and make you all perhaps reflect on. How do you define what is undefined and what is not explicitly stated in the Constitution? Who will define the concept of constitutional morality? We exist in a federal structure. We exist in a federal structure which is marked by a great deal of diversity. I was born in Mumbai, belonged to a small village about 60-70 kilometers away from Pune. My work took me to Allahabad as Chief Justice for 3 years, and now I look at the broader context of the Indian nation. And one thing which cannot but leave a very imperceptible mark on your heart and soul in the work which we do as judges in Delhi is to realize the importance of preserving the diversity of India. So how do we then dwell on the concept of constitutional morality? At one level, constitutional morality is founded in the preambular values, the values which the constitutional preamble sets out. But if these rights have already been enunciated elsewhere in the Constitution, then why constitutional morality? In fact, I was one of those who applied this concept of constitutional morality when I wrote the judgment in the first round of the battle between the NCT of Delhi and the Union of India about 6 or 7 years ago. And responding to that judgment, the learned Attorney General for India, Mr. Venugopal, asked me in another case, he says, Judge, where do you find this doctrine in the Constitution? It was an academic discourse.